Question 1. Topic: Trust administration. Fiduciary duties. During comprehensive review of process that needs improvement, trustee is found to have invested trust assets in business owned by their spouse. The beneficiaries claim this constitutes self-dealing and breach of fiduciary duty. The trustee argues that the investment has significantly increased the value of the trust assets based on fiduciary principles. Which of the following statements is accurate? A. The trustee has not breached their fiduciary duty if the investment was prudent and resulted in net gain to the trust. B. The trustee has breached their fiduciary duty of loyalty by engaging in self-dealing regardless of the financial outcome. C. The beneficiaries must prove that they suffered financial harm for the trustee to be liable for breach of duty. D. The trustee can justify the investment if they receive consent from at least one beneficiary. Answer B. The trustee has breached their fiduciary duty of loyalty by engaging in self-dealing regardless of the financial outcome. Explanation. The duty of loyalty is one of the most fundamental fiduciary duties imposed on trustees. Under the Uniform Trust Code SS 802, self-dealing is per violation of this duty, regardless of whether the transaction benefits the trust. The law does not consider financial gains as defense for self-dealing because it creates conflict of interest and undermines beneficiary trust. Why is incorrect? Fiduciary duty violations are not excused merely because they result in financial gain. Courts evaluate conflicts of interest, just outcomes. Why C is incorrect? The burden is on the trustee to prove the fairness of any transaction involving trust property, not on the beneficiaries to show harm. Why D is incorrect? Trustee must obtain consent from all beneficiaries or court approval for transaction involving potential conflicts of interest. Question 2. Topic: Wills. Revocation and revival in situation where formal requirements conflict with the testator's last known intent. An individual, Mark, creates valid will in 2015, leaving his estate to his brother. In 2018, he writes new will naming his spouse as the sole beneficiary and explicitly revoking the 2015 will. In 2022, Mark destroys the 2018 will but does not draft new one. Rather claims that this act revives the 2015 will, while his spouse argues that the estate should pass under intestacy laws. What is the likely legal outcome? A. The 2015 will is automatically revived because the testator's intent was to nullify the 2018 will. B. The 2015 will remains revoked unless Mark explicitly republished it before his death. C. The estate passes under intestacy laws because both wills are considered revoked. D. The court will distribute assets equally between the brother and spouse. Answer B. The 2015 will remains revoked unless Mark explicitly republished it before his death. Explanation. Under the Uniform Probate Code SS 2509, revocation of subsequent will does not automatically revive prior will unless the testator explicitly republished the revoked will, or there is clear and convincing evidence that the testator intended to reinstate the prior will. Why is incorrect? Simply destroying the 2018 will does not automatically reinstate the 2015 will. Why C is incorrect? If no valid will exists at death, intestacy applies. However, if the testator intended to revive the 2015 will, it might still be valid under state law. Why D is incorrect? The court does not automatically distribute assets equally. Intestacy laws determine distribution. Without proof of republication, Mark's estate will pass according to state statutes, likely favoring his spouse. Question 3. Topic: Estate and gift taxation. Federal gift tax. When implementing new protocols in shared environment, wealthy individual gifts $50,000 to each of their 5 grandchildren in 2024. They believe these gifts are tax-free due to the annual exclusion. However, an IRS audit reveals that part of the gifts may be taxable. Which of the following explains the tax treatment? A. The entire $250,000 $50,000 x 5 is taxable because gifts to non-spouse beneficiaries are always subject to tax. B. Each $50,000 gift is partially taxable because the annual exclusion only applies up to $18,000 per recipient in 2024. C. None of the gifts are taxable because they fall within the lifetime exemption amount. D. The taxpayer must report $160,000 in taxable gifts because only the first $18,000 per recipient is excluded. Answer D. The taxpayer must report $160,000 in taxable gifts because only the first $18,000 per recipient is excluded. Explanation. Under EAS SS 2503b, the federal annual gift tax exclusion allows individuals to give up to $18,000 per recipient 2024 amount without triggering tax. Any amount exceeding this limit is considered taxable gift. The donor made 5 $50,000 gifts, totaling $250,000. The first $18,000 per recipient is excluded, meaning $90,000, $18,000 x 5 is not taxable. The remaining $160,000, $250,000. $90,000 is taxable and must be reported on Forms 109 Gift Tax Return. Y is incorrect. Gifts to individuals are not always taxable. They may be shielded by exclusions and exemptions. YB is incorrect. The annual exclusion in 2024 is $18,000, not $18,000 per recipient. YC is incorrect. While the lifetime exemption, $13.61 million in 2024, may prevent actual tax liability, gifts exceed. The exclusion must still be reported. Unless the donor has exceeded their lifetime exemption, they will not owe tax immediately, but reporting is required. Question 4. During an emergency response where multiple areas are impacted, an executor of an estate finds that the decedent's estate is insolvent, with debts exceeding the value of the assets. The estate includes a mix of secured and unsecured debts, primary residence held in joint tenancy with surviving spouse, and some personal property. Several creditors have filed claims and the executor is determining the correct order of payment. What is the sequence of payments under estate administration laws in the case of insolvency? A. Pay secured creditors first, followed by administrative expenses, funeral costs, and then distribute remaining assets to heirs. B. Pay administrative expenses and funeral costs first, followed by secured creditors, then priority unsecured claims, and finally general unsecured creditors. C. Distribute all available assets pro rata among all creditors, treating secured and unsecured creditors equally. D. Pay all claims in the order were received regardless of the claim type or priority. Answer. B. Pay administrative expenses and funeral costs first, followed by secured creditors, then priority unsecured claims, and finally general unsecured creditors. Explanation. Estate insolvency is governed by probate and estate laws, which dictate the priority of payments when debts exceed assets. The general rule under Uniform Probate Code UC SS 3805 and similar state laws is administrative expenses, e.g., court fees, executor fees, legal costs are paid first. Funeral and burial costs follow. Secured creditors, e.g., mortgage lenders, can claim collateral or may receive payment if assets allow. Priority unsecured claims such as taxes owed to the government are next. General unsecured creditors, e.g., credit card companies, personal loans are paid last, often receiving little or nothing if the estate lacks funding. Options A incorrect, because secured creditors do not always take priority over administrative and funeral expenses. C incorrect, as estate laws do not treat all creditors equally. There is strict hierarchy of payments. D incorrect, since creditor priority is based on law, not on when claims are received. Question 5. While analyzing the root causes of sequential problems in estate planning, a testator executes the formal will, leaving their estate to multiple beneficiaries. However, the testator later drafts a handwritten letter detailing new asset distributions that contradict the original will. The letter is neither witnessed nor notarized, but is found alongside the will after the testator's death. One beneficiary claims the letter represents a valid codicil. Under the applicable will execution laws, what is the likely legal outcome? A. The letter is invalid because it lacks witness signatures and proper formalities required under traditional will execution laws. B. The letter is valid as a codicil as long as it clearly shows the testator's intent and is signed by them. C. The letter can only be valid if all beneficiaries agree to its terms and formally waive any objections. D. The letter is automatically valid under all state laws as an informal testamentary document. Answer A. The letter is invalid because it lacks witness signatures and proper formalities required under traditional will execution laws. Explanation. Wills and codicils must follow strict execution requirements under state laws and the Uniform Probate Code UC SS 2502. Formal wills require written documents signed by the testator and witnessed, typically by two individuals. Holographic wills, handwritten wills are valid. Some states have signed and dated without requiring witnesses. Codicils, amendments to will, must meet the same execution standards as wills. Incorrect options. B. Incorrect, because not all states accept unsigned, unwitnessed documents as valid codicils. C. Incorrect, since beneficiary agreement does not override legal execution requirements. D. Incorrect, as informal writings do not automatically become valid testamentary instruments. Dead law. Question 6. During a major transformation where existing methods of estate planning are evolving, a trustee of an irrevocable trust is considering decanting the trust to modify its terms without seeking court approval. However, one beneficiary objects, claiming the trustee does not have the authority to make such modifications. Under modern trust laws, when is a trustee permitted to decant the trust and what limitations exist? A trustee can always decant an irrevocable trust as long as it benefits the trust's beneficiaries. B. Trustee may decant trust only if state law or the trust instrument expressly grants such power. C. Trustee cannot decant any irrevocable trust because its terms are fixed upon creation. D. Trustee can decant the trust in all cases without notifying beneficiaries or the court. Answer. B. A trustee may decant a trust only if state law or the trust instrument expressly grants such power. Explanation. Decanting refers to a trustee's power to transfer assets from one trust to another with different terms, effectively modifying the trust. This process is governed by state trust laws, including the Uniform Trust Decanting Act in states that have adopted it. Key considerations. Many states allow decanting only if the instrument permits it or state law provides for it. Trustees must act within fiduciary duties and cannot decant solely for personal benefit. Beneficiary consent may or may not be required depending on state law. Incorrect options. A. Incorrect, as trustees do not have unlimited decanting authority. C. Incorrect, because modern laws allow some modification of irrevocable trusts. D. Incorrect, since most states require notificate beneficiaries or court approval. Question 7. In a situation where formal requirements conflict with evolving case law, a surviving spouse elects to take an elective share against a deceased spouse's will. The will disinherits the spouse, but state law guarantees minimum inheritance. What factors determine the spouse's right to an elective share? A. The elective share is only available if the spouse was named in the will. B. The elective share is calculated based on the net probate estate, excluding non-probate assets. C. The elective share includes certain non-probate assets, depending on state law. D. The elective share can only be taken if the spouse proves financial need. Answer. C. The elective share includes certain non-probate assets, depending on state law. Explanation. Elective share. Statutes exist to prevent disinheritance of a surviving spouse and provide them with a guaranteed portion of the estate. Under Uniform Probate Code SS2 202, the elective share is typically percentage G1, 3, or 1/3 of the augmented estate, which may include some non-probate assets like joint accounts and certain trusts. Can override the terms of will if the spouse chooses to elect against it. Incorrect options. A. Incorrect, because the elective share applies regardless of the will's provisions. B. Incorrect, since non-probate assets may be included in the calculation. D. Incorrect, as elective share rights do not require proving financial need. Question 8. A testator executor will leave in their entire estate to their 3 children in equal shares. However, years later, they establish a revocable living trust and transfer all their assets into the trust, naming only one child as the sole beneficiary. After the testator's death, the other 2 children contest the estate plan, arguing that the will should govern the distribution of assets. How will the court likely rule? A. The will controls distribution, and the assets must be split equally among the 3 children. B. The trust controls, because the assets were transferred to it during the testator's lifetime. C. The will and the trust must be read together to determine the testator's final intent. D. The will overrides the trust because it was executed after the trust was created. Answer. B. The trust controls, because the assets were transferred to it during the testator's lifetime. Explanation. Revocable living trust takes precedence over will for assets that were properly transferred into the trust. Since the testator placed all assets into the trust before death, those assets are no longer part of the probate estate and are governed by the trust's terms. A. Incorrect, because the will only controls assets in the probate estate. C. Incorrect, because the trust is a separate legal entity and is not interpreted with the will. D. Incorrect, because later executed will does not override trust unless it specifically revokes it and proper steps are taken. Question 9. A trustee managing an irrevocable trust invests trust funds in highly speculative stocks, resulting in significant losses. The beneficiaries sue, alleging a breach of fiduciary duty. What is the most relevant legal standard the court will use to determine the trustee's liability? A. The trustee is personally liable for all losses, regardless of the circumstances. B. The trustee is only liable if the investments violated the prudent investor rule. C. The trustee is not liable because investment losses are a natural risk of managing trust. D. The trustee is only liable if the beneficiaries prove intentional wrongdoing. Answer: B. The trustee is only liable if the investments violated the prudent investor rule. Explanation: the prudent investor rule, adopted in most states, requires trustees to invest trust assets prudently and diversely to minimize risk. A trustee may be liable if they failed to diversify investments, made excessively risky decisions, or did not act in the best interest of the beneficiaries. A. Incorrect, because a trustee is not automatically liable for losses. C. Incorrect, because losses must still be evaluated against fiduciary duties. D. Incorrect, because negligence, not just intentional misconduct, can result in liability. Question 10. The decedent will leave large portion of their estate to a friend who was also their caregiver. However, the decedent's family challenges the will, claiming undue influence. What key factors will court consider when determining whether undue influence occurred? A. The decedent's health, dependency on the beneficiary, and whether the will deviated from prior plans. B. The size of the estate and the number of beneficiaries named in the will. C. The number of witnesses present when the will was signed. D. The decedent's relationship with the caregiver at the time of death. Answer: A. The decedent's health, dependency on the beneficiary, and whether the will deviated from prior plans. Explanation: courts examine whether the testator was vulnerable to undue influence based on physical or mental condition at the time of execution, dependence on the beneficiary, significant deviation from previous wills or estate plans. B. Incorrect, because estate size and number of beneficiaries alone do not indicate undue influence. Incorrect, because having witnesses does not automatically negate undue influence. D. Incorrect, is simply having close relationship does not prove undue influence. Question 11. A business owner dies, leaving behind a company structured as a sole proprietorship. The heirs are unsure how to handle the business's debts and assets. What legal rule applies to the transfer of sole proprietorship after the owner's death? A. The business automatically dissolves and creditors seize all assets. B. The business is considered part of the owner's estate and transfers through probate. C. The employees inherit the business by default under labor laws. D. The business remains operational until court determines its fate. Answer: B. The business is considered part of the owner's estate and transfers through probate. Explanation: sole proprietorship has no legal distinction between the business and the owner. Upon death, the business assets and debts become part of the estate. The probate process determines ownership transfer. A. Incorrect, because the business does not automatically dissolve. It depends on estate administration. C. Incorrect, because employees do not automatically inherit the business. D. Incorrect, as the business does not continue indefinitely without ownership resolution. Question 12. The settlor creates an irrevocable trust and later regrets the decision, wishing to regain control over the assets. Under what circumstances, if any, can an irrevocable trust be modified or terminated? A. Never. An irrevocable trust cannot be changed under any circumstances. B. Only if all beneficiaries consent and court approves the modification. C. Only if the trustee agrees without needing beneficiary or court approval. D. Only if the settlor proves they were under duress when creating the trust. Answer: B. Only if all beneficiaries consent and the court approves the modification. Explanation: irrevocable trusts are designed to be unchangeable, but modifications are possible under Uniform Trust Code Address S 411, allowing changes if all beneficiaries agree and the court finds modification appropriate. Decanting laws, allowing asset transfers to new trust with different terms in some cases. A. Incorrect, because modification is possible under specific legal conditions. C. Incorrect, because trustees alone cannot unilaterally modify an irrevocable trust. D. Incorrect, as proving duress is difficult and rarely results in trust termination. Question 13. An estate includes jointly owned real estate with rights of survivorship. One co-owner dies and there will leaves their estate to their children. What happens to the real estate? A. The deceased owner's share transfers to their children through probate. B. The surviving co-owner automatically inherits the entire property. C. The property is split between the surviving co-owner and the children. D. The executor decides how to distribute the property. Answer: B. The surviving co-owner automatically inherits the entire property. Explanation: Joint tenancy with right of survivorship JTROs means that upon one owner's death, the surviving co-owner automatically inherits the property, bypassing probate. A. Incorrect, because joint tenancy property does not pass through probate. C. Incorrect, because ownership does not split between co-owners and heirs. D. Incorrect, as the executor has no authority over JTRO's property. Question 14. During a major transformation where existing methods are being replaced by new frameworks, decision-makers must assess how legal considerations impact estate planning. Which of the following is the most critical factor when determining whether a will should be updated? A. The age of the testator at the time of the last will update. B. Changes in estate tax laws and personal circumstances. C. Whether the executor of the will is still alive. D. The number of beneficiaries named in the will. Answer: B. Changes in estate tax laws and personal circumstances. Explanation: wills should be updated when there are significant changes in tax laws, assets, or personal circumstances, such as marriage, divorce, birth, or death of a beneficiary. A. Incorrect, because age alone does not require a will update. C. Incorrect, because a new executor can be appointed if the original is deceased. D. Incorrect, as the number of beneficiaries does not automatically invalidate a will. Question 15. When implementing new protocols in a shared environment where multiple stakeholders are involved, how can an executor efficiently manage the probate process to minimize disputes? A. By distributing assets informally before court approval. B. By strictly following the will and legal requirements while maintaining transparency. C. By negotiating separate agreements with each beneficiary outside of probate court. D. By liquidating all assets immediately to simplify distributions. Answer: B. By strictly following the will and legal requirements while maintaining transparency. Explanation: an executor has a fiduciary duty to follow the will, comply with legal procedures, and communicate clearly to prevent conflicts among beneficiaries. A. Incorrect, because distributing assets before court approval can result in liability. C. Incorrect, because separate agreements may violate the will's terms. D. Incorrect, since liquidation is not always in the estate's best interest. Question 16. In a situation where formal requirements conflict with practical concerns, what happens if a will is missing a legally required signature in a jurisdiction with strict execution laws? A. The will is invalid and cannot be enforced. B. The court may consider alternative evidence to determine intent. C. The executor can still distribute assets based on the will's contents. D. The beneficiaries can agree to enforce the will informally. Answer: A. The will is invalid and cannot be enforced. Explanation: many jurisdictions require strict compliance with will execution laws, e.g. signatures, witnesses. A missing signature often renders the will invalid unless an exception applies. B. Incorrect, because intent cannot override formal legal requirements in strict compliance states. C. Incorrect, as an invalid will cannot dictate asset distribution. D. Incorrect, because informal agreements do not carry legal weight in probate court. Question 17. While analyzing the root causes of sequential problems in estate distribution, an executor discovers that some assets are jointly owned with rights of survivorship. What impact does this have on probate proceedings? A. These assets bypass probate and pass directly to the surviving owner. B. These assets become part of the probate estate and must be distributed accordingly. C. The executor has discretion over how to distribute these assets. D. A court must decide whether the joint ownership is valid. Answer: A. These assets bypass probate and pass directly to the surviving owner. Explanation: joint tenancy with rights of survivorship JTROs allows assets to transfer outside of probate directly to the surviving co-owner. B. Incorrect, because JTROs assets are not subject to probate. C. Incorrect, as the executor has no control over these assets. D. Incorrect, unless there is a legal dispute over ownership. Question 18. When scaling up operations that experience significant legal challenges, how can a trust be structured to minimize estate taxes while maintaining access to assets? A. By using an irrevocable trust to remove assets from the taxable estate. B. By keeping all assets in a will-based estate plan. C. By transferring assets to a surviving spouse through a basic will. D. By using a revocable trust which removes assets from the taxable estate. Answer A. By using an irrevocable trust to remove assets from the taxable estate. Explanation: irrevocable trusts remove assets from an individual's taxable estate, reducing estate taxes. B. Incorrect, because will-based estates are subject to probate in estate taxes. C. Incorrect, as spousal transfer may defer but not eliminate estate taxes. D. Incorrect, since revocable trusts do not remove assets from taxation. Question 19. In a multi-location scenario where consistency requirements impact estate administration, how should an executor handle real estate located in different states? A. By filing ancillary probate in each state where property is owned. B. By transferring all properties to a single jurisdiction's court. C. By automatically distributing the properties without court involvement. D. By liquidating all real estate to simplify distribution. Answer: 8. By filing ancillary probate in each state where property is owned. Explanation: ancillary probate is required when an individual owns real estate in multiple states, as each state has jurisdiction over properties within its borders. B. Incorrect, as probate laws are state-specific. C. Incorrect, since real estate transfers typically require court approval. D. Incorrect, because liquidation is not always necessary. Question 20. While updating traditional approaches where interconnections exist between estate planning tools, what advantage does a revocable living trust offer over a will? A. It allows assets to bypass probate while maintaining control during the grantor's lifetime. B. It eliminates all estate taxes for the grantor's heirs. C. It prevents all legal challenges to the grantor's estate. D. It ensures the court must oversee all asset distributions. Answer A. It allows assets to bypass probate while maintaining control during the grantor's lifetime. Explanation: revocable living trust allows individuals to manage and control their assets while alive and avoid probate after death. B. Incorrect, as estate taxes depend on federal and state laws. C. Incorrect, because trusts can still be challenged. D. Incorrect, since one main benefit is avoiding court intervention. Question 21. During an emergency response where multiple areas are impacted by sudden legal changes, which of the following could invalidate a power of attorney, POA? A. The principal revokes the POA. B. The principal moves to another state. C. The agent declines to act immediately. D. The POA document is misplaced. Answer A. The principal revokes the POA. Explanation: a power of attorney remains valid until revoked, expired, or the principal becomes incapacitated if non-durable. B. Incorrect, as POAs are usually valid across states. C. Incorrect, because an agent's refusal does not invalidate the document. D. Incorrect, since losing the document does not affect its validity. Question 22. In an environment where different components must interact for estate planning, what role does a pour-over will play when used with a revocable trust? A. It transfers assets into the trust upon the grantor's death. B. It replaces the need for trust. C. It prevents changes to the trust's beneficiaries. D. It eliminates the need for an executor. Answer A. It transfers assets into the trust upon the grantor's death. Explanation: pour-over will ensure any assets not already in the trust are transferred upon death, reducing probate involvement. Question 23. While investigating a complicated issue between different legal jurisdictions in estate planning, what challenge might arise when administering an estate with assets in multiple states? A. Different states may have conflicting probate laws that require separate proceedings. B. The executor can freely distribute assets without court intervention. C. All assets automatically transfer to the next of kin without legal action. D. A single probate process applies nationwide for all estates. Answer A. Different states may have conflicting probate laws that require separate proceedings. Explanation: estate administration can be complicated by varying state laws, often requiring ancillary probate in each state where real estate or certain assets are located. B. Incorrect, because probate laws often require court oversight. C. Incorrect, as automatic transfers only occur in specific cases, such as joint ownership. D. Incorrect, probate laws are state-specific rather than uniform nationwide. Question 24. During a comprehensive review of a process that needs improvement, an estate planner suggests using a revocable living trust. What primary benefit does this provide over a will? A. It avoids probate and allows for private asset distribution. B. It ensures automatic estate tax exemption. C. It prevents any future legal disputes over assets. D. It eliminates the need for an executor. Answer A. Avoids probate and allows for private asset distribution. Explanation: revocable living trusts are designed to bypass probate, ensuring faster and private asset distribution. B. Incorrect, because estate tax liability depends on federal and state laws. C. Incorrect, as trusts can still be legally challenged. D. Incorrect, since a trustee instead of an executor manages the trust. Question 25. In a high-stakes environment where multiple challenges affect estate planning, what is a primary risk of not designating beneficiaries for financial accounts? A. The assets may be subject to probate, delaying access for heirs. B. The financial institution will automatically distribute the funds equally. C. The executor can decide how to allocate the funds. D. The assets will be immediately forfeited to the state. Answer A. The assets may be subject to probate, delaying access for heirs. Explanation. Counts without designated beneficiaries may become part of the probate estate, delaying distribution and potentially increasing legal fees. B. Incorrect, because financial institutions do not distribute assets without legal authority. C. Incorrect, as an executor must follow probate rules. D. Incorrect, since assets only go to the state in cases of escheat. Question 26. When implementing new protocols in a shared environment where legal updates impact estate planning, which document is essential for ensuring medical decisions align with a person's wishes if they become incapacitated? A. Living will or advance healthcare directive. B. Last will and testament. C. Revocable living trust. D. Power of attorney for property. Answer A. A living will or advance healthcare directive. Explanation. A living will or advance directive provides instructions on medical care preferences if someone is unable to communicate their wishes. B. Incorrect, because a last will only governs asset distribution after death. C. Incorrect, as a trust manages financial assets, not medical care. D. Incorrect, since a power of attorney for property relates to financial decisions. Question 27. While analyzing the root causes of sequential problems in asset distribution, what is one drawback of using a payable on death (POD) account instead of a trust? A. It does not provide asset management if the owner becomes incapacitated. B. The designated beneficiary cannot be changed after initial setup. C. The funds must go through probate before distribution. D. It increases estate taxes for the beneficiaries. Answer A. It does not provide asset management if the owner becomes incapacitated. Explanation. A POD account only transfers assets after death but does not offer financial management during incapacity. Unlike trust. B. Incorrect, because beneficiaries can be updated anytime. C. Incorrect, as POD accounts avoid probate. D. Incorrect, since POD accounts do not automatically increase estate taxes. Question 28. In a scenario where efficiency decreases across multiple estate planning tools, why might an irrevocable trust be used instead of a revocable trust? A. It removes assets from the taxable estate, reducing estate taxes. B. It allows for easier modifications after the grantor's death. C. It automatically revokes all wills previously created by the grantor. D. It ensures assets are distributed immediately upon the grantor's passing. Answer A. Removes assets from the taxable estate, reducing estate taxes. Explanation. An irrevocable trust removes assets from the grantor's estate, helping to reduce estate taxes. B. Incorrect, because irrevocable trusts cannot be easily modified. C. Incorrect, since trusts do not revoke wills, though they can supersede them. D. Incorrect, as trusts distribute assets based on trust terms, not immediately. Question 29. During an emergency response where multiple areas are impacted, an estate executor discovers that the decedent did not update their will after a major life event. What is a likely consequence? A. The outdated will may not reflect current legal and personal circumstances. B. The assets will automatically go to the next of kin, regardless of the will's contents. C. The executor can revise the will to include new heirs. D. The court will ignore the will and distribute assets based on current state laws. Answer A. The outdated will may not reflect current legal and personal circumstances. Explanation. A failure to update a will can result in unintended asset distribution and potential legal disputes among heirs. B. Incorrect, because a will, even outdated, is still legally valid unless challenged. C. Incorrect, as executors cannot change wills. D. Incorrect, since courts only apply state laws if a will is invalid or absent. Question 30. When developing a solution that must address opposing needs in estate planning, why might someone choose a charitable remainder trust? CRT? A. It allows a grantor to receive income while providing a future charitable donation. B. It ensures all assets are distributed equally among family members. C. It eliminates all estate taxes for the heirs. D. It allows the grantor to modify beneficiary designations freely. And so A, it allows a grantor to receive income while providing a future charitable donation. Explanation: a charitable remainder trust CRT provides a steady income stream for a period of time, with remaining assets going to charity, offering tax benefits. B, incorrect, because CRT assets are designated for charity, not family distribution. C, incorrect, since estate tax benefits depend on the CRT structure. D, because CRT terms are typically irrevocable.